Start. A division bench of Odisha High Court in the case of Maguni Devi versus Gaurang Sahu Supra has held that the provision of Order 18 Rule 3A is couched in affirmative terms. It prescribes a certain procedure but imposes no penalty for its non-observance, and the rule itself provides an exception and gives discretion to the court to permit the examination of a party at the later stage for reasons to be recorded by it. It has further been held that in interpreting a code of procedure, it would be useful to keep in mind that the rules of procedure are intended to aid the administration of justice and not to hamper it. They should be used as aids rather than as obstacle. The relevant paragraph 10 to 12 are extracted herein below. A directory provision is generally affirmative in its terms, but negative words are ordinarily used as a legislative device to make a statute imperative. If the requirements of a statute which prescribes the manner in which something has to be done are expressed in negative language, that is to say, if the statute enacts that it shall be done in a particular and specified manner, and in no other, then those requirements are in all cases absolute, and the neglect to obey or fulfill them exactly will invalidate the whole proceedings. The provision of Order 18, Rule 3A is couched in affirmative terms. It prescribes a certain procedure but imposes no penalty for its non-observance. The rule itself provides an exception and gives discretion to the court to permit the examination of a party at a later stage for reasons to be recorded by it. That indicates the anxiety of Parliament to ensure that the subordinate courts should not shut out evidence of a party which is necessary for a just decision of the case. It could not have been the intention of the legislature to debar the court from permitting examination of a party even though the just decision of the case demands it. The paramount consideration of the judicial process being the doing of justice to the parties. The court can examine a party at a later stage if it considers the evidence essential despite some negligence on the part of a party. In interpreting a code of procedure, it would be useful to keep in mind that the rules of procedure are intended to aid the administration of justice and not to hamper it. They should be used as aid rather than as obstacles. Lord Buckmaster once pointed out, all rules of court are nothing but provisions intended to secure proper administration of justice. It is therefore essential that they should be made to serve and be subordinate to that purpose. Procedure has been described to be handmaid and not a mistress of law, intent to subserve and facilitate the cause of justice and not to govern or obstruct it. Like all rules of procedure, this rule demands a construction which would promote this cause. A general rule: evidence should never be shut out. Parties should be given full opportunity to give evidence if the justice of the case demands it. However negligent or careless may have been the omission of the litigant to examine himself and the commencement of the evidence of his side. The same should be allowed if that can be done without violence to the statute or irreparable prejudice to the adversary. There is no injustice if the other side can be compensated in terms of costs. Now, a code of procedure must be regarded as such. It is procedure something designed to facilitate justice and further its end, not a penal enactment for punishment and penalties, not a thing designed to trip people up. Too technical a construction of sections that leaves no room for reasonable elasticity of interpretation should therefore be guarded against, provided always that justice is done to both sides, lest the very means designed for the furtherance of justice be used to frustrate it. Next, there must be ever present to the mind the fact that our laws of procedure are grounded in a principle of natural justice which requires that men should not be condemned unheard, that decisions should not be reached behind their backs, that proceedings that affect their lives and property should not continue in their absence, and that they should not be precluded from participating in them. Of course, there must be exceptions, and where they are clearly defined, they must be given effect to, but taken by and large, and subject to that proviso, are laws of procedure should be construed wherever that is reasonably possible in the light of that principle. It is useful to quote the quoted passage of Lord in 4AC 404 in this connection. Procedure is but the machinery of the law, after all, the channel and means whereby law is administered and justice reached. It strongly departs from its office when, in place of facilitating, it is permitted to obstruct and even extinguish legal rights, and is thus made to govern when it ought to subserve. The harm and inconvenience that will result from holding a provision to be mandatory should be weighed against the harm and inconvenience that will result from holding the provision as directory. The conclusion which results in greater harm should be avoided, as that could not have been the intention of the legislature. Courts have been set up to administer justice, and wide discretion has been vested in them, so that the paramount purpose doing of justice to the litigating parties may not be frustrated. It is therefore a cardinal rule not to interpret a provision in a statute in a manner which abrogates judicial discretion unless Parliament has explicitly or by necessary intendment curtailed or withheld the same. If the provisions of the rule are held to be mandatory, grave hardship and injustice will be caused to the litigants. Without the evidence of the party himself, justice cannot be done in most cases. If, however, the rule is held to be directory, a party no doubt will be put to some inconvenience, but he will not go without any remedy. If the party examining himself at a later stage introduces new facts, it will be open to the opposite party to ask the court to recall the witnesses for further cross-examination under Rule 17 of Order 18 CPC, and he can be compensated by costs. Over.